Is it on? Okay. Good morning, everyone. You can slowly get settled. All right. Good morning once again, and very much welcome to the conference titled Collaborative Pathways to Integrity. My name is Vigjilenca Abazi. I am the co-founder and executive director of the European Whistleblowing Institute, the organization leading this initiative together with our partners, which are the Network of National Authorities, Transparency International, Whistleblowing International Network, Transparency International Greece, EDHEC, University of Galway, and University of Göttingen. We are delighted to have this first of its kind conference where the ambition for us has been to not only have civil society or national authorities or academics discuss these topics, but really to bring for you in the same room for each and every single panel common perspectives in terms of what are the main issues of whistleblowing and how we address them. It's a very humbling experience for me to be here today and give this opening because all of our speakers today bring so much wealth and depth and experience. I was trying to count the combined years of everyone who's been working in the field, and it was definitely exceeding 100, which is definitely more than actually what this topic has been as a scientific inquiry, or definitely not as a regulated topic as well. In my brief remarks, and before I actually give the floor to our honorable keynote speaker, distinguished speaker for today, I would like to just leave you for the entire day with a few remarks of why what we're doing here and why your work in whistleblowing is profoundly important. It cannot be said, and we cannot take it for granted, that we live in deeply fragile political times. Whistleblowing is not merely a relationship of an employee, whichever shape or form that employment relationship may take, with their employer, and therefore reporting on that potential misconduct or breach, but much more an act of democracy, an act of courage that actually calls to accountability, an act that talks about speaking up. And more than ever before, speaking up takes incredible amount of courage. Now, this speaking up takes place in an ecosystem, and all of you are part of that ecosystem in different parts of your own work. And this is why, for us, it was extremely important to make sure to have you in the room and to hear from your perspectives how we can actually improve the systems that are supposed to encourage whistleblowing, support whistleblowing, address the breaches that they take place. It is also a time where we have deep mistrust of institutions. And this is why having national authorities in every single panel for today is so important to examine what your role is, what you can do, what you're already doing, and what you can do better. It is also incredibly important that we have voices of civil society who are on the ground actively working to make changes and cultural changes in each of the states. We're also particularly happy and proud that we're bringing together a very pan-European conference, and including actually in the sort of language mix where in the second panel we will also have a moment of Spanish-English. So it's delightful in a way, in a truly European spirit, to have a European conference on whistleblowing. Without further ado, I wish you a very enjoyable and productive and fruitful conference. I genuinely am excited to have fantastic 4 panels that we have prepared for you. But before we go into all of that, we have our distinguished keynote. It is a great honor to present Judge Ninon Colneric, who's a former judge at the European Court of Justice, the first ever female German judge at that court, and quite frankly, to this day, the female presence is thin. But the judge has a lot of work, and especially on whistleblowing, under her belt. She's one of the lawyers that defended one of the key cases on whistleblowing in Germany. She's been an advocate of better protections and better implementations at the national level, also through her scientific academic work. And in addition to all that, she's been spearheading a collaboration for the China-EU School of Law, so going much more further beyond European borders as well. She's an honorary professor at University of Bremen and has been a president of the Regional Labor Court. So before you will have a speaker who is deeply, deeply knowledgeable, experienced, and has worked with the whistleblowing topic, both as a practitioner and as an academic, and more than anything, in the spirit of actually protecting the workers who have the courage to speak up. So please join me in thanking the judge as she takes the stage, and I wish you a very good conference.
Thank you for this kind introduction, and good morning to everybody. In 1999, the German constitutional judge Jürgen Kühling described the typical social environment of a whistleblower as follows. His behavior is classified as treason, is considered disloyal. A deeply rooted ethos of allegiance overrides the principles of enlightened ethics that approve his behavior. The development of whistleblowing law can be seen as a fight between these two approaches. The principles of enlightened ethics are on the rise, but the fight is not yet over. My talk will focus on this development and try to assess what stage we have reached in this conflict. I shall start with examples from my own country and then broaden the view. The early case law of the German Federal Labor Court illustrates what the ethos of allegiance means for whistleblowers. In 1949, this court held that a complaint filed by an employee against an employer who is acting unlawfully may constitute good reason for termination without notice. As late as 1995, a labor court relied on this ruling to dismiss the unfair dismissal claim of an employed veterinarian who had drawn public attention to signs of BSE, that mad cow disease you will remember, at a slaughterhouse. In German whistleblowing law, the Federal Constitutional Court started opening the door for enlightened ethics in 2001. It held that because of the rule of law, the exercise of civic rights in criminal proceedings cannot normally constitute a reason for terminating an employment relationship without notice, provided that no knowingly untrue or grossly negligent false statements are made. The German Federal Labor Court used the loophole in this sentence, namely the words normally, as a rule, to develop the doctrine that, in principle, internal clarification has priority. That means only if an internal report or clarification is unreasonable due to the specific circumstances of the individual case can the employee be entitled to make an external report. The court derived this requirement from the employee's duty of loyalty and confidentiality. The ethos of allegiance had won again. When the European Commission presented its proposal for a whistleblowing directive, it incorporated the principle that, in general, internal reporting takes precedence over external reporting. This triggered strong resistance from the European Parliament and numerous organizations from all over Europe, among them many journalists' associations and trade unions. Finally, in nocturnal trilogue negotiations, a compromise was reached. Direct reports via external reporting channels are permitted without restriction, but member states shall encourage reporting through internal channels where the breach can be addressed effectively, eternally, and where the reporting person considers that there is no risk of retaliation. This was a major victory for enlightened ethics. However, the European Court of Human Rights in Strasbourg did not keep pace with this development. The ruling of 2008 in the leading case Guia versus Moldova was still encouraging. It could be read as making no distinction between internal whistleblowing and disclosure to authorities, and only submitting disclosure to the public to a proportionality test based on 6 factors. But last year, in case Allais versus Luxembourg, the Grand Chambre of the European Court of Human Rights did not distinguish between reporting to authorities and public disclosure. It submitted all types of external reporting to the same set of rules, namely the 6-factor test. The first criterion concerns the channels used to make a disclosure. As a rule, the court gave internal reporting priority over external reporting, although it admitted exceptions. This lack of distinction between disclosure to authorities and disclosure to the public is the more amazing as the court was aware of the whistleblowing directive, which it extensively cited when setting out the relevant national and international framework. On the other hand, it must be noted that the European Court of Human Rights is more whistleblower-friendly than the Whistleblower Directive when public disclosure is at stake. The court gives considerable weight to the public interest of the disclosed information. No wonder the yardstick is whether the interference with the exercise of freedom of expression was necessary in a democratic society. The purpose of the European Convention on Human Rights, which that court applies, is to secure human rights. In contrast, the purpose of the Whistleblowing Directive is to enhance the enforcement of union law and policies in specific areas. So, in the perspective of the directive, whistleblowers are just a resource for law enforcement, which should, for this reason, be protected. Of course, upholding the law is an essential element of a democratic society. But this instrumental approach to whistleblowing falls short of fully grasping its role in a democratic society. While the EU is restricted by its limited competences, member states could do more, in particular with respect to public disclosure. But member states, with very few exceptions, are not the spearhead of whistleblower protection. The Whistleblowing Directive entered into force on the 16th of December 2019. With one minor exception, member states had to bring into force the laws, regulations, and administrative procedures necessary to comply with the directive by the 17th of December 2021. In January 2022, the Commission started infringement proceedings and sent letters of formal notice to no less than 24 member states for not fully transposing and informing the Commission of the transposition measures before the deadline. In the course of the year, it moved on to the second stage of infringement proceedings and sent reasoned opinions to 19 member states for failing to communicate measures fully transposing the directive. In February 2023, the European Commission decided to refer 8 member states to the Court of Justice of the EU. Finally, 6 member states were actually taken to court, Czechia, Estonia, Germany, Hungary, Luxembourg, and Poland. In all these cases, the Court of Justice of the EU imposed lump sums, in 2 cases, even daily penalty payments, because by the date of the examination of the facts by the Court of Justice, these states had persisted in their failure to fulfill their obligations. The highest lump sum was imposed on Germany, the impressive amount of 34 million euros. In their press release about this judgment and the judgments pronounced in 4 of the parallel cases the same day, the German Whistleblower Network suggested to use this windfall money for establishing a support and compensation fund at European level for whistleblowers who have suffered damage. I only remember one directive where implementation was so tardy on a large scale, namely the Equal Pay Directive of 1975, equal pay for men and women. In both cases, legislation was not just confirming a consensus, but had already developed in society, but trying to effectuate social change. It would be simplistic to attribute all the delays in implementing the Whistleblower Directive to the continuing influence of the ethos of allegiance. However, it was a major factor. Let me have a closer look at the German example. The main reason for the delay was that the Christ Democratic Party did not accept the wish of the Social Democratic Party to extend the material scope of the whistleblowing legislation beyond what was mandatory under EU law. Although one-to-one transposition was the general attitude of the Christ Democratic Party towards EU law, the persistence with which they pursued this policy in the case of the Whistleblower Directive was influenced by the ethos of allegiance. They had no interest in making the law transposing the Whistleblowing Directive a piece of legislation that is understandable for whistleblowers, because they had no interest in external whistleblowing. The report on the implementation and application of the Whistleblowing Directive, which the European Commission submitted to the European Parliament and the Council in July 2024, in that report, it stressed that the transposition of the directive was not just very late overall, but that it also needs to be improved in certain key areas, such as the material scope, the conditions for protection, and the measures of protection against retaliation, in particular, the exemptions from liability and the penalties. In Germany, the law on whistleblowing even contains this clause: the disclosure of incorrect information about breaches is prohibited. This blatantly contradicts the protection for persons who had reasonable grounds to believe that the information was correct at the time of disclosing it. So the fight goes on. And the fight goes on in a more fundamental way. Let me quote Jürgen Kühling, the German constitutional judge, once again. He said, "The law protects the dark secrets of the powerful, in our country too." According to Article 3, Paragraph 3 of the Whistleblowing Directive, it shall not affect the responsibility of member states to ensure national security or their power to protect their essential security interest. The German law transposing the Whistleblowing Directive contains the same kind of exception. I guess that Germany is not the only member state with that sort of legislation. We all know Edward Snowden and what happened to him. If his whistleblowing had occurred in the EU, he would not have been protected under the whistleblower directive. The same goes for 6 Israeli whistleblowers who were nominated for an International Whistleblower Award named after Daniel Ellsberg last year. You will remember Ellsberg had disclosed the so-called Pentagon Papers about the war in Vietnam and thus revealed the lies related to that war by several US governments in succession. The 6 Israeli whistleblowers were intelligence officers who had all served in the army during the current war in Gaza and were directly involved in the use of AI to generate targets. These men turned to the investigative journalist Yuval Abraham, also known as one of the directors of the Oscar-winning documentary No Other Land. Yuval Abraham himself summarized his report as follows, quote, "Our new investigation reveals that the Israeli army has developed an artificial intelligence-based program called Lavender, which has been used to mark tens of thousands of Palestinians as suspected militants for potential assassination during the current Gaza war." According to 6 whistleblowers interviewed for this article, Lavender has played a central role in the Israeli army's unprecedented bombing of Palestinians since October 7, especially during the first weeks of the war. In fact, according to the sources, the army gave sweeping approval to for soldiers to adopt Lavender's kill lists with little oversight and to treat the outputs of the AI machine as if it were human decision. While the machine was designed to mark low-level military operatives, it was known to make what were considered identification errors in roughly 10% of cases. This was accompanied by a systematic preference to strike Lavender market targets when they were in their family homes, along with an extremely permissive policy towards casualties, which led to the killings of entire Palestinian families, unquote. One of the automatic systems that were used specifically to track the targeted individuals and carry out bombings when they had entered their families' residences was called Where's Daddy? Yuval Abraham's report spread like wildfire around the world. Abraham hoped that what he had so clearly set out in his report would help people all over the world to demand a ceasefire, the release of the hostages, an end to the occupation, and a political solution. However, he looked beyond Gaza. As he explained in an interview with Democracy Now!, he sees the use of artificial intelligence in warfare as a danger to humanity. In his opinion, this type of warfare makes it possible to evade accountability. International law is in crisis. The use of artificial intelligence in war will deepen this crisis. That's what Yuval Abraham said. The International Ellsberg Whistleblower Award was finally not awarded to Abraham's anonymous sources, but following the personal wish of Daniel Ellsberg himself, to Daniel Everett Hale. Hale informed the public about the severe grievances, civil casualties, and government misconduct regarding the US drone warfare. In 2019, he was arrested and charged under the US Espionage Act, a law passed during the First World War against spies, but later used to retaliate against whistleblowers. When he was released from prison in February 2024, he was in such a bad shape that he was unable to accept the award in person. All these whistleblowers followed the principles of enlightened ethics. But what can we do to protect people like them? Should we admit that in such cases we reach the limits of law. Law is increasingly under attack. To give you just some examples, you will know that the International Criminal Court issued an arrest warrant against the Israeli Prime Minister Netanyahu. Nevertheless, the future German Chancellor Friedrich Merz declared that he would invite him and not have him arrested. The US imposed sanctions against staff of the International Criminal Court, first of all against Karim Khan, the chief prosecutor of the court. And already in 2002, the US adopted the American Service Members Protection Act, known informally as the Hague Invasion Act. The act gives the President of the US power to use all means necessary and appropriate to bring about the release of any US or allied personnel being detained or imprisoned by, on behalf of, or at the request of the International Criminal Court. I could continue this list, and you probably too. Nevertheless, there seems to be at least one tool granting protection if whistleblowers want to inform the public of atrocities committed in the name of national security. That is the protection of journalistic sources. As long as journalists have a right to keep their sources secret, whistleblowers are comparatively well protected. However, that right is at risk too. Thus, last year, the London home of the British journalist Asa Winstanley was raided by roughly 10 police officers before 6 a.m. Electronic devices were seized. Winstanley is an opponent of Israel's oppression of the Palestinians. The police suspected him of encouraging terrorism. The chilling effect of this measure was also felt in the EU. What conclusions can we draw from this brief overview? The adoption of the Whistleblowing Directive was an important step towards enlightened ethics. It reflects a shift in the public's perception of whistleblowers. However, the overall very late transposition and the many deficiencies of the transposing laws show that there was not wholehearted support for the approach of this measure. Let's do what we can to increase the directive's efficiency. As for the dark secrets of the powerful, they remain well protected. We can be very grateful to the courageous whistleblowers and journalists who nevertheless reveal them to the public, because in a democratic society, the public needs to know them. Thank you for your attention.